not into the mic here. Just out there.
It's not connected.
No, because it.
And, okay, can you hear us all?
Start recording, so there's an error. Oh, wait, it's recording.
Can you hear us?
No, see, recording has failed.
No.
That's it.
Yes. Yeah, there's a delay. Oh, okay. So we're depending on you to let us know if something gets too quiet and it can't be heard.
I tried it on a different USB. It changed out.
Roger. Okay. Am I holding still? Still holding, okay.
Oh, it's working. Working now? I don't know if I can hear.
You know, a key to wrapping up the meeting early.
It's working.
Starting on.
Yeah, is to, key to wrapping up the meeting early is to postpone it.
Sometimes USBs.
All right, we're good to go. So I will reiterate though, since we don't have mics. Speak slowly, speak clearly, speak loudly.
Okay. Okay. It is 6:36. Call the regular July 12th meeting of the Duck Planning Board to order. Public comments? Hearing none. We'll get on to new business, Ordinance 23-09, text amendment to Section 156162 of the zoning ordinance, authorizing the Board of Adjustments to grant continuances and adopt rules of procedure. Joe?
Okay, thank you, Mr. Chairman. As you mentioned, this one deals with the Board of Adjustment, and all we're doing with this ordinance is clarifying the board's ability to grant continuances and to adopt their own rules of procedure. So this ordinance was drafted by Town Attorney Robert Hobbs. So you have a copy of the ordinance in front of you. We did have one comment on this ordinance from Bren Chasen, who is not here tonight, but she just asked whether it uses a word, there's insufficient membership on the board as one of the reasons why someone can request a continuance. And my response to that question is that it says exactly what it needs to. In other words, it's not talking about a quorum. That's a whole different thing. But there are times when that board might have a quorum, but to grant a variance, a Board of Adjustment needs a supermajority vote, and they need 4 votes in favor. So if there are only 4 members in attendance, that puts an undue burden on the applicant to get all 4 of them to vote in favor. Even if 3 vote in their favor, that's not enough. So insufficient, and again, this is on page 1, number 1 with the 2 little i's. Insufficient membership of the board references that scenario, and someone can ask for a continuance from the board for that. So otherwise, the proposal is hopefully self-explanatory, but I'd be glad to answer any questions the members might have.
Thank you, Joe.
None for me.
No, sir. Okay. Do I hear a motion?
Speak loudly.
I move that that ordinance 23-09 text amendment to section 156.162 of the zoning ordinance authorizing the Board of Adjustment to grant continuances and adopt rules of procedure be passed by this body.
Okay, the motion's been made and seconded. Any further discussion?
No.
All right, let's put it to a vote. All in favor?
Aye.
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 Unanimous? Good, okay. Second item of new business, ordinance 23-01, text amendment to sections 156040 and 15058 of the zoning ordinance, clarifying where and under what criteria wireless telecommunication facilities are permitted. Joe?
Thank you, Mr. Chairman. This one was an ordinance that was generated by the staff based on issues that we had run across over the last year. And we just probably need to clarify, and as you see in the memorandum, the council agreed and asked us to work with the board to come up with something a little bit to clear up a couple of issues that we've run across. So one of those is that we had a use table for all the uses in the zoning ordinance, and that's in 15640. We have a separate table, and this deals with part one of the ordinance, okay? Part one. We had a separate table that was in the wireless telecommunication facility ordinance, and it included two other types of wireless facilities. We're just simply proposing that those be added to the overall use table in 15640, and you see how they're outlined there. This is already done in the wireless thing, but this way it's clearer for anyone who's looking at our ordinance where these things are allowed. And so we included a stealth antenna and a small wireless facility. So that's part one. Part two deals with a different issue, in that it was unclear in our ordinance the allowable height for a small wireless facility, or for the utility pole that supports that facility in cases where they're not using an existing pole. So we took our cue from the state regulations that were adopted back in 2017, and whereas it allows us to treat residential differently, we've chosen to do that, and our existing ordinance sets a maximum height of 40 feet for single-family residential. We're proposing to clarify that that height is 50 feet in rights-of-way, public rights-of-way, and commercial areas. So that's what that proposal is doing, that consistent with the allowances of the state. And those are the two different things, the two different issues that this ordinance is trying to address. And I'd be glad to answer any questions the board might have.
I think we might have a typo under part two, item B as well. It says 8 of new. I think it should be each new. So we just need to fix that error.
Okay.
Am I correct in that? Joe?
Yes, it looks like that's correct.
Part two, item
Part 2, the first two words of section B should not be 8 of, it should be each.
Each of new,
Each new or modified utility poles.
and strike of also.
Correct.
Correct.
Thank you for noticing that.
Any questions for staff? Joe? No, sir.
I had no question about the change. I have just a question in general about these stealth antennas and these small wireless facilities. What kind of activity are you seeing with those in town?
We have never, to my knowledge, had a proposal for a stealth antenna. It's a good idea, but we haven't had a need for that. So we haven't had to activate that one. We have right now at least one of these small wireless facilities. It's located on Scarborough Lane, right next to the shops, just south of the shops. Do we have any others presently?
I don't believe we have any others
Okay.
presently, but I know we have at least one application in, and we've had several other inquiries from a variety of different.
So we have one active application that'll go up by the Sander Lane area. And we have in the commercial area there at the Sander Lane. And we have another that, we've had a couple other locations that have been bantered about by Verizon over the years. One north of the village and one south of the village. But we don't have any applications, anything formal yet on those.
I guess like anything, the stealth antennas, individuals could have purchased those and actually have them. And just by their size and their nature, you may not know they're here.
They typically require an electrical permit at the minimum.
And these are telecommunications, so these aren't for individual use. So the companies they usually deal with another company that does the locations for them, and they always contact us. So we would be aware if we had one. But it's allowance. It's actually a good thing in certain situations where it can be hidden, and serve its intended purpose without the need for something that the whole community would notice, like you said.
Joe and Sandy, are these poles they're putting up in Southern Shores related?
You have some of these,
three of
the
them now.
small wireless facilities in Southern Shores.
And if I remember correctly, Joe, from when we did this in 2017, we were required by state statute, right,
Correct.
yeah. I mean, I realize it's pointless, but I would just make the comment again that if we want Dominion to put our infrastructure underground, which we do, permitting them to rent poles, which is obviously so lucrative that they're putting poles in for the facilities in Southern Shores and then renting them, is counterproductive, because they're not going to want to put the infrastructure underground if they're making money off of the poles being above ground. But if we can't do anything because of state law, I guess we can't.
We can't, they're allowed in the public rights of way. They do have to obtain a permit for the town, but we have to approve that permit as long as they meet the standards that the state has laid out, which our ordinance includes.
Understood. To me, this just seems like housekeeping, and I'm comfortable with it, as everyone else is. Do I hear a motion?
I move that ordinance 23-10, text amendment to section 156.040 and 15.058 of the zoning ordinance clarifying where and under what criteria wireless communication facilities are permitted, that it be approved as presented.
With the correction noted by staff. Okay, do I hear a second?
Is this, I'm sorry, did you say that number again? Did you say the right number?
Yes, you did.
Yeah. I assume I did. I read it from the page.
You did.
Okay.
Okay, the motion's been made and seconded. Any further discussion?
Negative.
Do I hear let's put it to a vote. All in favor?
Aye.
Aye. It's unanimous. Okay, next item, old business. Ordinance 23-07, text amendment to sections 30.35 through 30.40 of the town code, providing a description of the duties of the planning board. Joe?
Mr. Chairman, this is a continuation of our discussion, and items 4A and 4B are included in this. 4A is the ordinance that establishes the planning board and authorizes its duties. So at the last meeting, the board had one item that you had asked. If you turn to attachment B, we highlighted that change that we made. So it's highlighted in yellow. The board members wanted to just clarify that there is an oath of office required before service on the board, so that was added in under 3037D. And then the other item that the board reached consensus on was it ended up in the rules of procedure, and it had to do with meeting attendance. So if we flip over to attachment C, I believe it is, yep, with the draft rules of procedure. So again, these are internal policies that the board has, and it was changed for someone who misses 2 consecutive regular meetings or 3 during a 12-month period beginning each May 1st, that the board could recommend that that person be considered for removal. The board would have to ask the council to do that because only the council can make appointments or remove a member. So those are the 2 changes that there was consensus on, and we've highlighted the areas where those changes were made according to the wishes of the board. The other items that we have on there is that the board, Ms. Chasen did ask a question about, in her comments, about, or she was basically comment, there was a change that had already been made the previous month, but she notes that in the very first section, under 30.37, that the change was made. You're recommending that the members be full-time residents of the town. Her comment to that was that if so, people who are renting would then be eligible, and that is correct. You know, if you're a full-time resident, you would be eligible. What it does is it eliminates out-of-town property owners, but the board had that conversation and was in agreement that that was the intent of your recommendation. So I just wanted to bring that up. You know, that was a question or comment of hers. And yeah, she's correct that that would occur if that was a change. I didn't know what else, Mr. Chair, if you had wanted to have any further discussion on items, but otherwise we've updated the draft ordinance and draft rules of procedure according to the comments that have been made at past meetings. So I'll leave it up to you as to whether you want any additional discussion or whether you're ready to move the ordinance on to council.
Okay.
Yeah. Go to rules of procedure again.
Okay.
And state that.
Joe, can you speak up?
Pardon?
Speak
State
up.
that. Yeah, okay. The guidelines for meeting attendance were amended to missing 2 consecutive or 3 regular meetings within a year. Where did we end that? Right there? Is everybody in favor of that? You of all.
The answer is yes.
All right. I don't know, for some reason, I think that that's rash on us. I've been on this board for almost 18 years, and I've never seen a problem. So all of a sudden now we're putting one down there, and if a guy has a relative that's dying or something else, and it happens sometimes conceivably for several times, who knows? He could get kicked off. What's the intent?
There was in-depth discussion in the last meeting about excused and unexcused
Right.
absences.
Okay,
And
that's not here, though.
that didn't make it in.
No?
No.
Why?
I think it was the consensus of the group.
Okay.
I agree with what you're saying.
Without rehashing it yet again, I think the intent is to encourage people to be here, not the legitimacy of their excuse.
Well, I agree with you, except that it's been so good for so many years. And you've only been on a board for what, 5? Roughly?
6 or so.
Yeah, 6 or 7.
7.
Okay. I'll go along.
If we weren't addressing everything else in here, I would be inclined to agree. But this is addressing a whole bunch of stuff that hadn't been an issue or has been an issue, so.
If I might just add a comment here, you know, I've been here for 20 years. And in the 20 years that I've been here, I can think of maybe one planning board member who may have had gotten 2 consecutive meetings and maybe 3 within a year. they left on their own will. Typically, if you have a member who is not able to make the meetings, they are either going to resign or they're not going to be asked to be reappointed.
I think you're absolutely correct, and that's what one member did most recently. Tim? But, you know, if we're putting rules of the road, we might as well put it down. But, you know, you would think that a thoughtful member, knowing you would not be able to be here, conscientious member would just resign. But
And I would also add that this is the rules of procedure, so as Joe mentioned, this would come to you before it gets recommended to council.
Right.
So ultimately, the planning board has they make the determination as to whether they're going to send this to council.
Yeah.
So if there are extenuating circumstances, you can discuss them.
I think during our discussion, that was how we came to an agreement to let it be that limiting, was because we still had two levels of discretion. One, our vote, and then council had to also reiterate.
I would say that's the part I have a problem with. I don't want to sit here and have to vote on the legitimacy of someone's excuse. And I think it puts all of us in a hard position to vote on the legitimacy of someone's excuse.
We do what?
So, you know, this, you know, I don't want to vote that your excuse is more legitimate than Bob's excuse, who is more legitimate. Because obviously your excuse is legitimate to you, Bob's excuse is legitimate to him, Mark's excuse is legitimate to him. And I don't think it's for me to vote, so I think the rules ought to be clear. The intent is for people to attend meetings, and if you can't attend the meetings.
Well, I feel like we've already deliberated this, and we deliberated it with the full board, and when we did that, this was the conclusion that we came to. And I feel like the compromise was that we left it in the rules and procedures rather than put it in the ordinance. And if I'm interpreting that as how it's presented to us tonight,
That's not what's here.
that is the rule. That's the rules and procedures section, is it not? Yes, yeah, that's not the draft ordinance. So, yeah, all things, assuming that that's all correct, I'm comfortable with leaving it how it was deliberated with the full board. I do have one additional question regarding Brent's comment. It just drew my attention to full-time resident as a definition. The state provides a definition for that?
Okay. Not to my knowledge.
Okay, then it seems plausible that potentially, I realize this is not the section that we're talking about tonight, but we could make a correction there and say registered voter. That would be a very clear definition.
Well, why not say living?
It could be another way of doing it, and that's more definable. I guess someone could choose not to vote or register to vote, and they could be a full-time resident 12 months a year, but if they don't register to vote, then, you know, are you depriving them of a right?
I'm looking at Lauren for this question.
Yeah.
I don't know that I would use register to vote as the context for this. There's a range of things that impact someone's ability to register to vote.
Right.
To be eligible to do that. And I don't think you want to get to the weeds on that sort of requirement.
I agree.
understand the intent to make sure you have someone who is here, who spends their time here, who's invested in the area. And there might be a way that, a definition that to streamline that. I think full-time residence is probably as narrow as you're gonna get without getting too far in the weeds right now. Now, it's not, doesn't say that staff and Robert, I guess, can try to fine tune that at a later time, but for this draft, I think full-time residence addresses the concern over a property owner. There is a field that can be much more.
I agree with that.
And Mr. Chairman, don't forget that these are two separate documents the rules of procedure will not go on to town council. You know, that's an internal document that the board has. So you could tweak this if we could have some further discussion on that point and tweak it further, okay? But the ordinance is what goes to the town council. They don't adopt your rules of procedure, you adopt those.
I understand that, but I'm talking about the language that Bren mentioned is in the draft ordinance. And that was what drew my attention to the full-time resident
Yeah,
definition.
Okay.
But I wouldn't have even,
I got
I would
you.
have just read over it, but then when she said renter,
I got you, okay.
but if it's not a big deal, it's not a big deal to me. I just was curious.
I think that expresses the intent that I'd like to see there, which is a,
The intent, and I will not, I don't want to represent that there's not wiggle room there, because I, as an attorney, live in the world, and full-time resident means, yes, it could be a renter. So full-time resident does mean they could be a renter, not a property owner, and that is true. But I do think it narrows the field to address the person you want to be eligible to serve on this board.
but we never held any discussion that would prohibit a renter as opposed to a property owner from being on the board. So I don't see a need for deliberate further.
Yeah,
Well, and certainly given the variety of different ways in which property can be titled.
Yeah.
Let's say Susie could own our house, and so I'm not a real property owner,
Right.
but I'm a full-time resident.
And I will also note that because the council makes the appointment, you have another layer of protection in terms of even if somebody is a renter or something, you have somebody else looking over
Right.
the eligibility. So I think that the way it's drafted identifies the clear intent and purpose of the candidates you want to eligible to serve on this board.
And I might also point out that you are going one step further than any of the other communities in terms of defining residency. The others all say, they all just simply say shall be residents of the town. They don't say full-time or part-time. They don't specify that. So you're adding that additional feature.
Got it. Okay. Any further discussion?
No, going back to the other one, is that finished?
No, we have to vote, though. Or I need a motion, and then we have to vote. James is doing all the work tonight, since you guys are just talking about
What I mean, it's going back to send someone away from the board. We're finished with that?
We're finished with it because it's in the rules and procedures and not, unless you're not finished. But as Joe pointed out, we can take it up at any time in the future because it's our document.
Like we could take the whole thing out?
Like anytime we don't have something on the agenda, we can have just a meeting to talk about it.
Okay.
It's fine. Okay.
Keep us from belaboring this discussion.
Yes.
I move that we approve ordinance 23-07, text amendment to sections 30-35 through 30-40 of the town code, providing a description of the duties of the planning board as presented.
I will second.
Okay, the motion's been made and seconded. Further discussion? All in favor? Aye.
James,
I move,
did I get 4 ayes?
yes, yeah,
Okay,
yes.
unanimous.
I move that we adopt the planning board rules and procedures as presented here tonight.
Second.
And I will second that.
Motion's been made and seconded. Further discussion? All those in favor?
Aye.
Aye. It's unanimous.
Okay, Mr. Chair, we will provide those rules of procedure to the council for their information, just so you know. Okay.
Thank you. All right, next item of old business, ordinance 23-11, text amendment to applicable sections of the town code, removing the planning board from the approval process for special use permits.
All right, Mr. Chair, we gave you a teaser of this at the last meeting, and that is why we have the presence of Mr. Womble with us this evening. This is another ordinance that is being proposed by the town attorney after researching the planning board's duties and authorizations. He had been asked to look specifically at the board's involvement in reviewing special use permits and has made a recommendation.
Yeah.
You'll see that it encompasses several different sections of the town code. And I will let Ms. Womble
Yeah.
say anything she wants, about this proposal. We had sent out some additional information. You have a memo from the town attorney, but you also have from the School of Government that article that we had sent around to you as well. And with that, I'll turn it over to her to add any comments that she would like.
I don't have any additional comments. I felt that Robert's memo covered everything in detail. The School of Government article is great. David Owens is always a go-to. So if you have any specific questions or want to discuss anything, I'll be happy to answer those questions. But I think the memo.
Attorney Womble, has an issue arisen that gives rise to this item?
So I'm not aware and Robert might be the one who could answer that specific question. I didn't ask him that, but I think that part of reviewing these ordinances and making changes is to make sure that the
Is her mic working?
to head off as much any issues that would come up in the future, right? So if as council we see a landmine, we try to avoid it, we try to plan for it. And so certainly when Robert was reviewing all these sections, this is probably one of those things he identified. I'm not aware of an issue that came up specifically for the town that gave rise to that.
And we are not aware of a specific issue where this has been called into question.
I think he said they weren't aware, were not.
They're not, yeah, he said he is not aware of an issue, an incident for the town.
So just an observation or two. I guess David Owens article
Yes.
certainly points out a few advantages, perhaps, of the planning board's involvement in these matters, such as, I don't know if he used the words trial run, but basically an opportunity to go through something and have a review, a more formal review of a special use permit before it gets to the council. And there certainly have been, I guess, a number of cases over the years where an item came before the planning board and it didn't proceed to the council because of questions that came up as a result of the planning board's review. And, I'm curious as to whether, whether or not town staff views the discontinuance of planning board's involvement as a negative or a positive from your standpoint.
Well, that's a good question. I think the things that the planning board does well, the value that you add to the process, is in your ability to focus on development issues. You know, the town council is dealing with dogs on the beach and e-bikes, and, you know, they're dealing with a whole variety of issues. They count on you to help them better understand development-related issues. So I think that's the value that the board has always had in terms of your involvement in the process. Now, what I can tell you as a professional planner is that for a decade, I've attended conferences, you know, state planning conferences, different training things, and it's been taught to us over and over that the quasi-judicial process, you know, it's tighter than, you know, an ordinance or rezoning, a legislative process. You have a lot of flexibility, but with that quasi-judicial process, there is a specific board, and in this instance, the council has chosen to be that board. They could give that power to you. They could give it to the Board of Adjustment. They have chosen to accept that and be the final decision maker. So legally, that makes it a question as to what can the board really do without overstepping the boundaries of, you know, that quasi-judicial process. You know, you have to do a really good job of keeping your focus on the issues that you can deal with and not get into the politics of something, you know. And so it presents a challenge to you as a board and to the town in terms of, you know, if a case is ever challenged, you know, it becomes a little bit iffier, you know, with the board's involvement, because it gives an opportunity for a savvy attorney to say, you know, look, the board did this and they shouldn't have, that kind of thing. So those are some of the pros and cons. I would say we'll work with it either way. I mean, that's our job. We don't have a preference one way or the other, but those are some things that we see.
I agree with Joe's comments, and I would add to his comments that I certainly like to think what happens here, and certainly what happens in other jurisdictions, is that a planning board brings technical, can bring more of a technical review and input than if it's a separate decision-making body can do, because they're dealing with lots of issues. So I would like to think that this planning board would bring more technical input in reviewing it than is typically found on a decision-making board. I have served on another planning board, but it made the final decision. It didn't make a recommendation to the town council. The other thing that I think is important is the comment by the School of Government in recommending what the planning board in this instance should do, and that's on the third page of their memo, paragraph 3 at the top. The planning board needs to focus on the standards set out in the ordinance for a special use permit and how those standards apply in the particular application. And I think that's very important. I think we have not done that all the time in the past, and I think that's our job.
So I would say, just from a legal perspective, I think that, and I know Robert, and I know the staff values everyone's review and technical review of those permits, but the issue is not the quality of review or the issues that you focus on in that review. It's the impact that your review actually can have on the process. And so when your comments come up, so I was here for one of the quasi-judicial hearings, and the planning board needed to give a comment, and I kind of skipped right over because you were back there with the public comment, right? And so when the board is considering in a quasi-judicial hearing comments from the public or things like that, they consider that the planning board's recommendation doesn't carry any more weight than any other information that they received. In fact, boards are usually instructed in the preliminary comments to not give weight to the planning board recommendation because the information you receive is not the same. It's not under oath. It's not necessarily the competent evidence that the board can rely on to make the decision. And so it's not the quality of the review, it's not necessarily what you were reviewing, because that's certainly going to be important and helpful. And
Except in my case.
except in your case, no. But what I'm saying is really the issue here is not the type of review, the quality of review, or what you review. It is the impact that your review can have on the quasi-judicial proceeding. And so because it can only carry as much weight as maybe a public comment, right? Because you're not necessarily under oath either, it really is not competent evidence for the board to consider. And they have to only consider evidence that's under oath and been admissible through the process. So then the question is, why do you do it? And is it worth the legal risk on the backside that if somebody does challenge the board's decision to, let's say if the council denies the permit and says, we're going to deny the permit because items A through D, and that happens to be the same items that the planning board identified as problems, and they say, we recommend disapproval because items A through D. And the applicant says, well, the council didn't actually consider our application. They just rubber stamped the planning board's decision. They didn't consider this, they didn't consider that. And that leaves a legal opening, if you will. So that's really the question is, it's the balance of those two factors. Because certainly your comments and review are only helpful. So
I think what you just indicated, Attorney Womble, is covered in the School of Government memorandum of what to do. Items 1 through 3. And I would disagree a little bit with the notion that clearly, desirably, a planning board makes some technical input that should.
Think they do. Think they do.
Desirably, they do. That should be considered by the decision-making body.
So I appreciate Joe's comments about, our contributions, but serving on the planning board for 11 years or more, I have seen in the last 5 or 6 more split decisions where we would approve or disapprove something and then council would do the opposite. I have heard comments from council members about relying, in council meetings, about relying on our recommendation. I don't feel like in our hearings we have kept to the substance of the ordinance. I feel like we've relied heavily on public comments. And so I've read the School of Government article, and I think the School of Government article, in contrast to the town attorney's letter, kind of explores both sides. But I mean, and then additionally, I've been on the other side as an applicant, and I can tell you that a shorter process and a process that's heard by people that are elected rather than appointed feels much fairer. It does put a lot on that meeting. A lot's riding on that meeting to get your point across clearly and to communicate your proposal. But I see the point of the town attorney and do feel like moving in that direction. Now, it's interesting to me, Joe, I did not realize that you pointed out that council could put that responsibility on the planning board or the Board of Adjustments, and it's possible that they might move in that direction in the long term. But I do feel like having it heard by one board in one quasi-judicial hearing is fairest to the applicant. And I think in the end, that's what we're shooting for.
Now,
And I would certainly agree with your point about the efficiency of the whole process. If I look back at the CDAG's application, and that got resident in Maine, and the number of trips he had to make deduct, one of which was to present his case to the planning board. And, I'm sorry, not,
They're not working.
not without some expense to him, I'm sure, but the whole process could have been accelerated had the planning board not been involved. And I think on balance, I agree, Mark, with you. It's, given what we've heard here tonight, it's best that the planning board not be involved in these decisions and these matters going forward.
I will note, though, it does not prohibit you as an individual to engage with staff and review the applications and appear at the meeting and give a comment to the council based on your review. And I'm certain staff would welcome your comments and in the preparation of their review and staff report.
So as a planning board member, does familiarity with the ordinance, serving in that function, give you standing as a witness at the hearing or no? So you're just making a public comment?
You would just be making a public comment as an individual. You know, I think that staff makes it, when there's an application, staff makes an analysis of the application. They review it, they review issues. If they received a question from the public about an issue, I'm sure they would assess that issue as part of their application review. But if you were to come and attend a hearing, it would just be public comment.
I think that speaks volumes for the case of not having us hear the applications. We don't meet the criteria as having standing to comment aside from as members of the public. So
therefore, it should not be in our,
right, not in our purview.
Yeah.
okay with me.
So, and I'm assuming that there's, in the previous text amendments that we just approved, I don't recall seeing anything under our responsibility, such as planning board, that would include responsibility for reviewing special use permits.
Correct.
Correct.
Yeah.
Actually, on the first page, on the very first page in the ordinance, you have a section that is crossed off, section 30-40C. That is a power and duty that under the ordinance moving forward that the planning board would have to determine to review site-specific development proposals, and it would involve removal of that authority.
Okay.
So that one would be a change.
Oh, that covers special use permits?
Correct.
Yes,
Okay.
yes.
Since they weren't named, I didn't realize that.
It was just cleaner to keep it separate.
I got you. Okay.
Yeah.
So that begs the question, is there any need to go back and review what we've already approved?
This ordinance would come after the other one, so if, the reason is that this is a different issue. You know, we understand that the board might come to a different conclusion regarding this ordinance than you did to the other one, and so we kept it separate.
Okay.
All right, further discussion?
Thank you.
All right, no further discussion?
None.
I'll entertain a motion?
I don't even know with all the planning.
You'll entertain.
Yeah, are you going to make it?
Yeah, but I don't know which sections we didn't make.
This one.
Yeah, I know the section, but we're just doing this.
Hey, as approved.
I would make a motion that we approve item C, ordinance 23-11. That's it, right?
Yep.
Okay,
As presented.
as presented.
And I will second that.
Okay. Motion's been made and seconded. All in favor?
Aye.
Aye.
Call,
All those opposed?
No. Opposed.
so 3-1 vote.
I know you're just going to throw it in.
We get started now. I'm not sure where we're going to get.
Okay. Next item is approval of minutes.
Oh, wow.
You ready for a motion?
Yes.
I move that the minutes be approved as presented of the,
Did submit a copy of an engineer's report on the sewer drainage prior to the council meeting, and the council did approve that permit with the conditions recommended by the board. So just so you're aware, that one's moved forward. The other one that came at the same time was having a harder time getting an engineer to do their study. They should have used the same engineer, I guess. But anyway, so they have not been, they probably won't go to council until September. Okay, so just so you know.
so, I'm sorry, Joe, so you're saying the Amy Lane proposal was approved? Okay.
Yes, sir, with the conditions recommended by the board, one of which had already been satisfied with the drainage study that was done. The only other item you had the council did set a public hearing for their August meeting for the text amendment defining drug paraphernalia sales. So that hearing will occur on August 2nd. And that's all they had at the meeting that directly related to you. And I'll ask Sandy Cross, our senior planner, to give you some updates on projects. We've had some pretty significant things. So, go ahead.
So yesterday morning, we had a bid opening for our NC 12 resiliency project, which is a road raising project from approximately Dune Road to Sunset Grill. We did have 2 bidders, and so we have a viable bid, and we're working on some value engineering, and we'll be hopefully bringing a contract to council at their August meeting. so that work can start this fall. That will involve a sill along the shoreline. It will involve a living shoreline. It'll involve raising the road anywhere from 6 inches to 2 feet where it floods at Sea Colony, and reconstruction of the east side sidewalk as well as the west side sidewalk. So pretty big project. In addition to that, we also kicked off our west side feasibility study. Council budgeted money for us to develop a plan to see if a west side sidewalk from the village corridor down to the south end of town is doable. So you're going to see things coming forward on that note. Council also approved us to work on some pedestrian improvements related to the traffic study that we did in 2021. Remember in August, we all got out there and did a study. Bob was there, I remember that. Some of the recommendations that came from Brian Mayhew and Lauren Blackburn are now in the hopper for actual work. So we'll be developing the details in terms of what signage we need, what kind of road improvements we need, and so on and so forth. We are also finalizing plans for improvements from the south end of town to the Ocean Crest intersection. For those of you that bike or walk, you know the trail right there is only about 3 feet wide, and it goes up a steep hill, and then it comes down. It's not wide enough for 2 people to cross back in opposite directions. It also has a steep drop-off down to Duck Road, so several years ago we had them put in a cattle rail just to protect people from injuring themselves. Ocean Crest has historically managed that section of trail. They have agreed to let the town take it over, and so we're going to knock that hill down and make it an ADA-compliant 8-foot wide walkway, and hopefully have some stormwater improvements associated with it as well. Simultaneously with that project, because we're going to need to put in a retaining wall, we're also going to be doing one of our new retaining projects down at the retaining wall just north of Plover Drive. We have a schedule for the retaining walls to be replaced throughout town, and that's one of them. Joe mentioned 1156 Duck Road, which came to you last month, being delayed. Blue Point also had a CUP in with us last month, and they were delinquent getting us the documentation we needed to bring it to you. As of yesterday, which would have been the deadline for the August meeting, I still do not have additional documentation. So that may or may not come to you in August. It depends on what they can get us this week. We did receive another application for another retaining wall and fill, a much smaller one in comparison to what you've just dealt with. We do hope to have that for you in August, but I haven't had a chance to look at their application completely to see if everything's included. And I think I've talked enough. Did I miss anything?
No, it's more than enough.
Any board comments?
No.
None.
Okay. Motion to adjourn?
I move that the meeting of July 12th be adjourned.
A second that meeting.
Moved and seconded, all in favor?
Aye.
Aye.
Who seconded? I'm sorry.
We're adjourned.
We are adjourned.
Good.